Thank you very much to everybody who's joined us today for our talk about the art of persuasion in today's online world. And in a world where 70% of communication is considered to be non-verbal, how can you effectively present your position in a virtual mediation or negotiation? And I'm delighted to be joined today by Bianca Motley Broom. She is a mediator and arbitrator with Miles Mediation and Arbitration in Atlanta. She does a tremendous amount of personal injury and premises liability cases. And she is also, most importantly, mayor of College Park, where she is responsible, among others, with the safety and well-being of everybody in that jurisdiction. In addition to which, I'm joined by Steve Dunn. Steve is a full-time mediator and arbitrator with Miles Mediation and Arbitration in Charlotte. He is primarily involved or primarily handles mediations for commercial disputes, business litigation, and has an extensive background and is one of the preeminent mediators in that jurisdiction. Thank you very much for joining me. My name is Nigel Wright. I'm a mediator and arbitrator, again with Miles here in Atlanta, although I do work nationally, and my background is in all areas of insurance and commercial litigation. So perhaps I could start by asking Steve a question, because he seems to have the best background. He seems to have the best lighting. So in a non-verbal, where non-verbal communication is clearly important to negotiation, how do you present yourself in the best possible way?
Well, Nigel, I'm flattered by your comments. Thank you. I think that we can all agree that it is essential in negotiation to communicate clearly and to be understood. And many of us in the past several weeks have gotten a crash course in video conferencing, which is an aspect of our mediation and arbitration practice that I don't think many of us were expecting to become such a prominent part of our practice as quickly as it has. And so we've learned a lot recently about how to ensure effective communication online. And there are a few basic things that anybody can do to ensure that you are seen clearly and heard clearly, and in that way are understood clearly. One of the most important, and probably I think the most important things that you can do in a video conference is to ensure that the lighting on your face is in front of your face and not behind you. So one of the big mistakes that people make is to sit in front of a bright light, particularly a window. A lot of folks will sit in front of a bright window and they'll look like a silhouette. And that really inhibits the ability of the other individuals participating in the video conference to read their facial expressions. So if you just make sure that the main source of light in your room is in front of you and not behind you, you're most of the way there toward ensuring that you're communicating effectively online. Another thing that I find very helpful is to make sure that your camera is raised up so that it's looking straight at you and that you're not looking down at your camera like a laptop that's sitting on your lap. This again is more of the appearance. It's closer to mimicking the appearance that you would have in person, and it's an effective way to communicate. And finally, I will say that hearing is as important as seeing, and the biggest problem that we've encountered in video conferences of our negotiations and mediations is a feedback that can exist when the sound from your speakers is picked up by your microphone and creates an audio feedback loop. And so there are a few simple things you can do to prevent that from happening. The main thing is to set your volume at a level that's low enough that that's unlikely to occur. But however you solve the problem, it's important to test your video and your audio every time you get online. And I certainly do this myself. Every time I get on any video conference that matters, I will go through the process of manually testing my video and audio. And I've saved myself many times from when I got on this call, for example, I had the beach background going instead of the Miles office background going. And so by testing it, I was able to spare myself the embarrassment of showing up with the wrong background. And the same thing happens with microphone. I mean, there have been times when I've forgotten to turn the microphone on. And so if you test your settings and you take a few basic precautions to ensure that you look as good as you can and you sound as good as you can, you're going to be understood during the negotiation process, and that's going to help you be successful.
Thanks, Steve. I've noticed that the three of us have very different backgrounds. I've gone for probably the worst background because there's lots of detail and clutter, which means people may not be concentrating on what I'm saying. Steve, you have a very professional looking background, which looks like an office, even though we know that you're not in an office. And Bianca, you have a very plain background. And I was thinking about this earlier. There are actually some advantages to that. Perhaps you can talk about what you've done, because not everybody has access to a green screen. If you do try and order one, you probably find there's a 3-month delay. And so you have to make do with what you've got. And perhaps you could just talk a little bit about what you did and the effectiveness of it.
Absolutely, Nigel. We are in my office right now, but we also use that area for storage. And my husband, who's fairly handy, but I don't think it takes too much, basically set up a steel cable, and we got some canvas to hide some of the storage. So the storage isn't what you're talking about as you talk to me. Because certainly in a mediation or in any virtual meeting, we want people to be focused on the individuals. We don't want them focused on everything that might be going on behind them. Certainly when I have the opportunity to talk with folks during mediations, I like to see a little bit of what's going on in their life. You might have heard some dogs barking earlier because I've got 3 of them. And that is certainly an aspect of how we are doing business nowadays. But you don't want it to be a distraction to the point that you can't actually complete what you've set out to do. So my goal was basically keep it relatively simple and move forward from there.
Well, thank you.
Nigel, I know that you that I addressed some of the audio and video aspects of things, but I know you've got thoughts about how you present yourself, and that can be something as simple as what you choose to wear, but also your gestures and facial expressions. What are your thoughts on those things?
Well, I do think that's a critical part, and just because you can't be in the same room as somebody doesn't mean you can't communicate emotion through your expressions. Steve and I were joking earlier that the one expression I seem to have mastered is the raised eyebrow when I'm talking. I think that's probably about the only one that comes across clearly on the video, but you can see what people are thinking through their expression. And if you're negotiating, how you want to appear to the other side is a critical component of that negotiation. Now, obviously some negotiations are on the phone, so that's a lot harder, but with everybody using Zoom, or most people using Zoom or Teams, when you're negotiating, whether it's in a mediation or a bilateral contract, if you can see the other person and they are giving you an indication of what they think, they're often doing it in a non-verbal way. So being able to see them, if they're concentrating like this, that's one giveaway, possibly. If they're raising their head or making a sigh, that's also another giveaway. And these clues are the very same clues that you would use if it was an in-person negotiation. I think the difference is you can exaggerate too much in a virtual negotiation. So tone it down a bit. Things that might be fine in person because they appear natural may not appear quite so natural when you're on a video screen. So Bianca, you have a great interpersonal skills. And one of the things that you are known for is your ability to connect with people, which is critically important when you're trying to get things resolved. So, I've been talking, about my raised eyebrow, which seems to be the only thing I can do. What do you do to demonstrate your emotion when you're negotiating or dealing with somebody who's taken a particular position?
Well, I think I'm one of those folks, and thank you for that, Nigel, but I'm one of those folks that tends to connect with people based on our commonality. And so, as I said earlier, I observe. a lot of what I'm doing before we're actually engaged in negotiating is observing not only the person but their surroundings, if there are any clues there, or any particular cues where I know that we might find that level of commonality. So certainly, I've done some negotiations in the past couple of weeks where other people have involved their dogs, whether on beds or other places. So we've been able to talk about that aspect of things and how life has been juggling work, families, and all that with our animals. But there are always ways in which you can connect. I think sometimes it's a little bit more difficult and takes a little bit more time as over this medium as it would in person, but I certainly think it's possible, and it takes a little bit more effort, but I've enjoyed it. Obviously, this is different. This is different than what we've done on a daily basis in meeting in person and hammering out negotiations that way, but it's certainly not an insurmountable challenge. I think you just need to be more aware of how you go about it.
I would like to point out that one of the things that I've learned is that there are different ways of viewing this conference, right? Now, I don't know about this conference. I actually don't know what this looks like to our participants today, but on an ordinary Zoom conference, you can see it different ways, and you can choose to see it different ways. So you can have it set so that whoever's talking takes up the whole screen, or you can have it set so that you're seeing everybody who's participating in the conference on the screen at the same time. Or you can choose to focus on any one of the participants in the conference and just have them take up the whole screen the whole time, whether they're speaking or not. And so it's, I think, important to be mindful of the fact that the other folks participating in your conversation may be literally seeing it a different way from the way that you're seeing it. And to, I think, just assume that your face is on the full screen of everyone else who's participating in the conversation, so that you're mindful of how you might be coming across. I think the camera is a lot closer to our face than our fellow people might be in a big conference room setting. And so our facial expressions, our reactions are in some ways amplified or easier to see or come across more strongly in this context, particularly if somebody's intently focused on seeing how you are reacting to something. So it's just something to think about. That's just part of this new world that we are much more used to dealing with naturally in person.
Steve, I think that's a great point. And I know that I put a little bit of practice into how I'm going to be sitting and appearing on camera. And I was wondering if the two of you put some thought and some practice into that as well.
Well, you would think I haven't, given the way I'm sort of slouched slightly, but I do try. And I think if you are conscious of what's important, for example, good posture. Am I sitting up straight? Am I the right distance from the camera so that my face fills that part of the screen I want it to? Am I in the wrong part or the right part of my background? Am I tilting to one side or not? Do I keep going, which I'm very conscious of the fact I am? All these things are important to know, because if you know them, then you can at least try to control them. And if you're thinking about them, you've got a much better chance of doing that. So for me, practice is very, very important. And I think if you think about trial attorneys, when they go into court, that's not the first time they've rehearsed their argument. They've done it multiple times before often. And in addition to which, they will often sit in front of either mock jurors or colleagues and present the case. So what are they doing? They're practicing their argument, their art of persuasion, so that when they get into that venue, they are ready and they're able to adapt to whatever develops. And I think that negotiation online is exactly the same. If you go into a negotiation without having prepared beforehand, then it's unlikely that you're going to be word perfect, and it's unlikely that you're going to have thought of everything that you should have thought about during the course of that mediation.
Well, Nigel, we've talked about production values, which I think we all agree is extremely important in communicating effectively. Equally important toward our goal of reaching a negotiated agreement is the content of what we're talking about and how we present that content to our counterparts in a negotiation. And that's related to an umbrella topic that encompasses many subtopics that we generally refer to as emotional intelligence. How do you define emotional intelligence, and how do you bring it to bear in negotiation?
Well, thank you, Steve. I think that emotional intelligence is central to any negotiation. And it's really the capacity to be aware of and control your emotions in order to handle the relationship, not just judicially, but also with some empathy, so that the other party or parties believe and understand that you understand their position. And there are often a number of elements involved, and everybody has their own definition, but a couple I found on the web, which I think are quite useful. It's really, being self-aware. As I was saying, one of the things that I like to do is I punished myself by listening to my old web casts and realize, first of all, I'm pretty straight-laced. Secondly, I say a lot. Thirdly, I tend to tilt my head a little bit too much. So being self-aware is important. Being able to regulate yourself. I'm trying desperately not to say but I'm failing, but at least I'm aware, which means I'm probably saying it a lot less than I would have done otherwise. And also self-regulate, making sure that I'm not over the top, making sure that I'm not too emotional. For me, that's important because of my personality. I don't want to come across as having an extreme view, because that's not the role that I have when I'm negotiating. And then the motivation is also important. That's a critical factor for emotional intelligence. You need to know why you're doing something. And finally, it's really about empathy. Empathy, the ability to connect with somebody and to truly feel what they're feeling. That doesn't mean that you have to buy into their position. What it means is you have to understand what their position is from their perspective. And I think those are really the key elements. And if you can recognize when they're at play, you can decide whether or not they're important for you or your client or your party at that particular juncture. Just because emotional intelligence is at play doesn't always mean that it's the right tool to use to get what it is that you're seeking to achieve in a negotiation.
Well, as we were preparing for this presentation today, I thought Bianca made an excellent point about the importance of listening. And I think in my experience as lawyers, the biggest mistake that many of us make is to become so wound up in our perspective and our position that we're truly not able to understand or perceive the other side's perspective or position. And I'm guilty of this probably all the time now. I definitely was guilty of this as a younger lawyer, and I see it a lot among practitioners in mediation. The idea that we're all very convinced that we're right, and that's part of doing a good job as a lawyer is being able to be convincing of your position, but it can cause us to have on blinders. And Bianca, I thought you spoke very eloquently about the importance of listening. How does that manifest in your practice?
Steve, so often by the time parties get to the point where they're able to negotiate and they've come to the table, there is sort of that tunnel aspect that happens. So one of the things that we have to push through is that barrier of, I know everything about this. One of the ways that I find is that can be very, very effective for folks, especially individual litigants, when I'm talking about them, is to say, I know that this is something that has happened to you, that's brought you to this table. But as much as you care about it, no one else will care about it as much as you. And I don't say that to be rude, but it's simply the fact that what has happened to this individual, whether it's a business dispute, whether it's personal injury, whether it's a premises case, it doesn't really matter. It's happened to that individual. And try as they might, attorneys, jurors, anyone else dealing with it is going to be looking at it from a different perspective. And thinking about how that will play into a case is very powerful, because it's so difficult for us at times to think about any particular situation from someone else's perspective. And a good negotiation should allow both sides, or how many ever sides are involved, to be able to do that. And you only achieve that through listening. So it takes a little bit of willingness on all sides to make that happen. But once parties start that process, it's often much easier to have those conversations.
Steve, I've got a question for you. Are there any techniques that you can think of that would help in trying to change someone's position? Because after all, that's what negotiation is. You're seeking to advance your position, which is likely, in many cases, to be to the detriment or certainly not aligned directly with the other side's position.
Well, I like the way that you frame the question as being about change, because I think that is fundamentally what settlement requires. And I like to tell parties at the beginning of the process that if this were going to be easy and if no change was required, then we wouldn't even be here, because you would have figured it out by now. Something has to change in this dynamic in order for us to be successful in this process. And even as I'm saying that, I know that what everybody's hearing is like, yeah, I totally agree. Yeah, that guy's got to change. You know, the change has got to happen on the other side of the table, which is true, but only partially true. And you know, in reality, almost all of the time, change needs to exist within everyone in order for us to be successful in resolving a difficult dispute. So, how do we get there? My fundamental technique of mediation is to relentlessly steer the conversation toward the topic of settlement in all of its aspects. So that can be, you know, what are the terms going to be? That's kind of the most obvious, but also some of the why questions about, like, how does our approach to this negotiation reflect our values? Or what are our goals? Why do you want to settle? Or how much do you want to settle? And the whole point of all these conversational techniques is to have the participants in the negotiation articulating settlement type language. And the reason for that is because people tend to be convinced by the things they hear themselves say, not the things that they hear us say. And so the greatest mediator in the world is not one who's going to tell the parties how things are going to be and how they need to be thinking about their case, but rather to facilitate the conversation coming from the individual participants. And this is intimately related to the point that Bianca eloquently made a moment ago about the importance of listening. And so we ask open-ended questions. We ask about values. A couple of questions that I throw into just about everyone are, how do you normally make important decisions in your life, right? Because different people do that in different ways. Another thing I like to do is ask, you know, like on a scale of 1 to 10, with 0 being never going to happen and 10 being it's an absolute no-brainer, we're going to settle this case, you know, how optimistic are you that we're going to get it done today? And whatever the answer is, right, the follow-up question is, so let's say you come back and you say, I don't think it's going to happen. I'm at a 4. All right, that's fine. You're at a 4. But let me ask you this. Why didn't you say a 1? You know, why didn't you say a 2? I'm framing the conversation. I'm framing your next statement to be about why we are settling this case, or why we might settle, or why we can, or why we should, as opposed to why we can't, or why we're not, or why we're pessimistic, right? And so there are a variety of techniques that that lead us toward that goal, but fundamentally it's about hearing. It's about hearing what folks are saying and responding in a way that lets them know that they've been heard.
Steve, that's really interesting analysis. And what I also heard through your explanation is that you ask a lot of questions. And Bianca, what I was going to ask you is, to what extent do you feel that asking questions leads to a strengthening of your negotiation position?
I think it's key. It has to happen, because this is all about what works for the parties. So if as a neutral, you're going in and kind of dictating the terms, that may not be in the party's best interest. You need to ask questions in order to understand what motivates people and how you're going to get to that ultimate yes. I thought one of the great things that Steve said in asking people about how they envision settlement is giving them an opportunity to get beyond the place where they're stuck. Because essentially when people come and they want to resolve negotiations or they want to resolve a dispute, they are somewhat stuck. So asking those questions allows them to see the place that they can get to that's beyond where they are right now. And everyone has to buy into that to a certain extent to move forward. So asking questions, getting people to think beyond where they are is absolutely key.
Nigel, I got a question for you. We're talking about listening and hearing and, you know, cajoling and moving towards settlement and presenting well and understanding perspectives and all that stuff. And there's some of my hard-nosed litigator buddies would stereotype mediators as being just a bunch of guys sitting around a campfire singing Kumbaya and, you know, making peace and all that. And that's fine. I'm very comfortable with that stereotype, but I wonder, what are the limits of all this? You know, like what are there situations in your view in which what we're describing as emotional intelligence is unnecessary or even detrimental in a way?
That's a great question. And I think the answer is yes. If you think about it, emotional intelligence is really about building a consensus. And if you have strong emotional intelligence, you hope or believe that your ability to connect is going to persuade people. But it doesn't always. But one of the downsides of emotional intelligence is that you are always looking for consensus. And sometimes that's just not what you want. Sometimes what you want is what you want. And in that situation, you shouldn't necessarily be thinking about how can I build a relationship, how can I connect with that particular person. Now, those scenarios are more common in bilateral negotiations where there's no ongoing relationship. So, for example, personal injury claims lend themselves very well to a situation where, while the mediator may need emotional intelligence to try to bring the parties together, that may not be in the best interest of one or more of the actual parties to the dispute, because they may not have the same tolerance for making concessions. They may have objectives that are outside of a consensus and an agreement with everybody walking away happy. So you have to be very conscious of that. The other thing, which is one of my favorite topics, is that when you read a lot about emotional intelligence, it tells you how great it is and how it's the way to get ahead in business within large corporations. And I completely agree with that. It is. However, when you stop to think about it, some of the great tech icons of our time have been very low on the emotional intelligence front. And I'm thinking, you know, primarily of those icons who have perhaps been on television, perhaps have had films made about their life history. And they seem pretty focused and dynamic, and yet at the same time, they're incredibly creative, and they overcome almost, well, what to everybody else would be insurmountable problems, because they just have a single-minded approach, which is completely inconsistent with emotional intelligence. So you have to think about emotional intelligence as being a tool. And is it something you want to use? And if it is, how much do you want to use? Or is it critical for your negotiation that you maintain to a rigid one issue topic and relentlessly pursue it, which you may be able to do dependent on your A, relative bargaining position, and B, risk tolerance. And provided you've done that analysis, that might in fact be a better approach than trying to engage in emotional intelligence. Now, obviously, as a mediator, I completely disagree with that. But as a party, you have to think about those things because you're the one that makes a decision. And very often the parties don't make the decision consciously, but if they think about it, they are presenting one of those positions when they proceed into any kind of negotiation, whether it's a mediation or a contract discussion or whatever it happens to be.
Nigel, I think you make a lot of great points there. And Bianca, this leads me to a question that I had in mind for you, because I know you do a lot of personal injury stuff where, for better or for worse, a lot of times there's a number at the center of the negotiation that's really taken up a lot of space, right? And it's I always kind of chuckle to myself whenever I read an article about the art of mediation or negotiation, because a lot of times in a lot of contexts, that literature envisions the proverbial win-win, right? Where the idea is like, well, let's work towards something. Let's understand each other's values and sit around the campfire and sing Kumbaya and then come out with something that results in a win-win. Whereas in the nuts and bolts of a lot of litigation, it's a zero-sum game, right? Every dollar that the defendant is paying is, a dollar that it's a win-loss kind of situation. And a lot of times there's just one central term, and it's the number of dollars that takes up a huge amount of the discussion. And I wonder, as you're facilitating those negotiations, like how do you make it about more than money, or do you?
I think there's so much that's tied into it for a lot of people, especially folks who may not necessarily be well versed within the litigation process and understand all the nuances of it. There's a lot more than money that goes into it. Most of the time, when I'm talking with people who have been involved in personal injury cases, I'll say something along the lines of, if someone had said they would write you a check for what you've been through the day before this happened, would you have taken it? And most people say no. I just want to be where I was before this occurred in the first place. So I do my best to let people understand that despite the fact that we're going to have to come up with a number, that's not everything, because it will never get you back to where you were. And those are the constraints of the system that we have. But in negotiating it, you make that decision instead of 12 strangers. And there's power in that. There's a lot of power in that, because people, for the first time throughout the process, actually get a real say. And that is beyond a dollar number. That is, control matters. The ability to control your destiny to whatever extent you can has value in and of itself. So we talk a lot about that. We talk about what it means for someone who has no sense of this to come in and make that determination for you, and how that has felt throughout the entire process already, because there have been a lot of people making decisions prior to showing up to a negotiation. So we definitely talk about those values to a certain extent, because they are key in getting people to where they're in the headspace that they can negotiate a settlement.
So I just wondered whether we could switch gears a little bit and talk about some of the basics of negotiation, because I think there's a belief that everything has changed because we're now in a virtual world. And while a lot has changed, including potentially 70% of communication, a lot actually is still the same. So Steve, perhaps you can just talk about some of the key factors that you believe are important when negotiating.
Well, we in preparing for this, we looked at some of the typical guidance, the best practices for negotiation as stated by the so-called experts, and I'm not particularly persuaded by any of them. I think you really have to be yourself, and you have to take a case-by-case approach to things. And so I'll react to one that was suggested to me, which is that you should never make the first offer. I've seen more than one expert suggest that you should never be the one to make the first offer. And I just disagree with it. I see what they're saying. I see that there are pros and cons to making the first offer. But on this and on every other aspect of negotiation, where I'm going to come down is not some sort of absolute rule, but rather a prescription to just do it smart, do it the right way. It could be powerful and helpful to make the first offer, right? You just got to do it in the right way. And one of the things, regardless of what the top 5 tips and tricks for a successful negotiation are, the one for me that underlies them all is to communicate a message along with the proposal, right? So if you're making the first offer, I'm going to tell you what the number is, and I'm going to also tell you what I think the number represents, right? Am I intentionally being stingy with you? Am I trying to put my best foot forward and show you that we're really trying to make something happen here? Am I sending this number because I'm mad at what you just did? Or am I sending this number because I'm rewarding you for what you've just done, because I'm happy about it, you know? And I like to just be very explicit about that. It's one of the ways, as Bianca just touched on, to make conversations about more than just money, but it's also important in framing the conversation. So, you know, in my view, there are no absolute. My only absolute is that there are no absolutes, and there's many different ways to do this right and to be successful. What about you, Nigel? What do you think about, for example, the concept of using silence to your advantage?
That's a great question. And you noticed I resisted the temptation to have 3 minutes of saying absolutely nothing.
I thought you were going to pause a little longer than that.
I'm very conscious of the fact that we need to finish this on time and deal with some questions, because we've had some come in already. So I like silence because it's something that is very uncomfortable for most people, but it's also something you need to practice, because there is a tendency for people to fill the void. And so if you noticed, even between the three of us talking, we very often interrupt each other because we're anticipating a silence which doesn't happen, which would have given us that opportunity. So even here, where we're talking about using these techniques, we still can't help ourselves and still find ourselves interrupting. So I do like it, but it has to be at the right time, and you have to use it judiciously, and it has to be for meaning. Otherwise, you're just the person that has long pauses between every sentence or every position that you take. I think another question, and Bianca, I'm going to ask you this. How important do you think it is to go into a negotiation with the absolute belief that you are going to succeed?
I'm a positive thinker, Nigel. The glass is always half full, and I'm always optimistic that a case can be resolved until the very last minute. And even after that, I think that there's work that can be done if parties don't resolve it right then and there on the day of a negotiation. So I think that going into it with the thought that this is going to work can only help, honestly. I know that sometimes we'll start negotiations and I will hear from people, this is not going to settle. This is not going to happen today. And we end up changing people's minds because we keep on listening, we keep on talking, and we keep on pushing beyond people's comfort zones. So I only think that a positive attitude about the potential outcome of a negotiation is only a help.
And Steve, can I ask you a question? Because that was a great answer, Bianca. What about the proposition that you should never give anything without taking something in return?
Well, I don't believe in absolutes, Nigel, but I will say that as a general proposition, I always like to have the conversation be about more than one thing, if we possibly can. I love cases where there's a lot of balls in the air. There's a lot of things to talk about, and in the business litigation world, there's usually plenty, right? But I do think that there's something to be said in responding to a proposal or coming up with one of your own to the concept of give and take, to attach a concession to an ask, to say a tit for tat, you know, a little of this and a little of that. I'll give you on this if you give me that. What do you think?
I personally think that the best thing you can ask for is the answer to a question where you don't know the answer. In other words, information. For me, you become much better at negotiating the more information you have, the more knowledge you have. Even if the information given to you is not correct, it doesn't matter, because it demonstrates a mindset or an approach from the other side that you may not be aware of. So even if you think you're asking a question that should be easy to answer, and you either don't get the answer that you believe is true, or you just don't get an answer, that's also telling you something about how the other side is treating you at that particular juncture. And so for me, I love to ask questions, not just because as a mediator it gives you that information, but as a party negotiating, it tells you so much about what's going on in the other camp. And I think for me, that's critical to actually reaching a resolution of whatever it is that you're seeking to negotiate.
and we haven't talked about this at all. We don't talk a ton about it, but I also do domestic relations cases from time to time. And having those little wins can often give you momentum to get the entirety of cases done, when you can come back and, Steve, I'm sure you see it in the business context a lot with the level of complexity. Sometimes those little things that happen early that parties are willing to agree on can lead to the barriers breaking down to actually get some of those larger, thornier issues resolved, because there's this sense of momentum, progress, and the real opportunity that, okay, I am being listened to. I got this, I got this point, so I'm more willing to work on some of the bigger issues that are impeding a full settlement.
I think that's a great point, Bianca. And let's face it, oftentimes negotiation is an emotional process for people in every context. For almost everybody that we deal with, we're talking about one of the most important things that's going on in their life, and oftentimes the most important thing that's going on in their life. And people being emotional during the process is something that it can inhibit the process at times, but it's something that I choose to try to channel and redirect toward the subject of settlement. So if somebody's, and I don't get mad if people are, even if they're upset with me, and this happens because sometimes you gotta tell people things they don't want to hear as part of this process, and you're there not to be, you're everybody's friend on some level, but sometimes being a friend means telling you how things really are, and that's part of our job. And so, people react to that in different ways, but I welcome passion and emotion, and I just turn that into, an expression of understanding. Like, I get it. This is important, and it's not fun, and I'm not telling you what you want to hear, and I'd be mad if I were you too. And in that way, you honor the seriousness of the matter to the people who are involved in it, and you express empathy. I think that's closely related to this concept of emotional intelligence that we're talking about, which is not to try to talk somebody out of how they feel, you know what I mean? But rather to channel that into a productive direction about, this is making you upset, okay? This is not a fun process that you're involved in. All the more reason to find a way to get this thing done today.
Right.
And just on that issue, I think one of the things that I used to love doing when I was negotiating was always to give a win to the other side when I thought that they were losing. And what I mean by that is, if you have a particular position that you're seeking to achieve and you achieve it, if you can give the other side something in return, even if it seems relatively small to you, it might mean a lot to them. Because ultimately, if you're negotiating something, you've probably got to paper it up. So people can change their mind during that process. So you want somebody going into the resolution part or the negotiation, the conclusion part, with a very positive attitude. So if you have just extracted the most amount of money from somebody that you could possibly imagine, give them something back, just, even if it's just a small thing, because you're going to need their help to get that papered. Otherwise, they may find a way to sabotage whatever you thought you had agreed, and then you're back at square one. So I think that's something that I think is quite helpful in negotiations. We have a little bit more time left, so what I thought I would do is bring in Greg at this stage, who has just joined us. Thank you very much. And there are a number of steps to the negotiation process. And Greg, I wondered if you could kindly give us your top tips in terms of what you would like to, what you typically see during the course of a negotiation.
Certainly, and welcome everyone. Sorry I'm late. I was mediating earlier today and just finished. What I'm seeing, especially in this new reality within the Zoom platform and virtual mediations, is that preparation is key, informing me, getting me information to help, and then having access to the client. One thing that's important, I know we've talked, or you guys have presumably talked about a lot of things with emotional intelligence and things of that nature. I find the camera is very unforgiving. It picks up every nervous tick, every smile, every tell, and I'm using that to my advantage as a mediator, because people forget the camera's on and they might just go, or reveal how they feel about a certain thing. And we're able to pick up on that and talk about it. I also get a little bit more of a direct access because attorneys can't block their claims professionals or their plaintiff clients from me. I get equal access. Everyone's their own individual square. And I'm finding that that is giving me as a mediator similar or virtually similar access as I would in person. I'm using that to my advantage to both read the room, read the people, and respond and react accordingly. I think the art of mediation is reading the room and understanding how to communicate with people. And when you can see in and pick up little things, it all helps.
Thank you. And what I just wanted to ask was, do you have parties that practice with before they turn into mediation? What I mean by that is, do you know whether the plaintiffs sit down with their attorneys and go through, for example, Zoom, go through the negotiation, go through all that before they set foot in front of the camera? Or do you find that typically the lawyers have done that, but maybe not the clients?
Again, for me, I find that I'm taking advantage of this platform to practice with people. So for a large majority of my mediations, I'm actually getting to do that practice with them. And it serves a couple of purposes. It creates a familiarity. They get to see me. They get used to the technology. We work out all the bugs. We work out the people looking at the camera and pointing at it and figuring out what they're doing. We play with the virtual backgrounds. I see what you and Steve are using. And it creates sort of a training camp for purposes of the mediation, so that when we reconvene, there's a comfort level of familiarity, and there's a trust more in me because I'm the teacher who taught them how to use it, and that creates a little bit better of a feel of trusting in something that's out of their control. And then that's what we're dealing with fundamentally in all mediations. People are taking something very near, dear, and important to them, and they're asking a stranger who they're meeting for the first time, whether it's in person or in Zoom, who's this guy or who's this lady, and why should we trust that person? When we've taken the time to orient them, it just creates that trust level that we are able to parlay into some successful mediations.
Thank you. And then a question, I think this one for Steve. Can you talk us through what a best alternative to a negotiated agreement is?
Well, that's a term that's used in the language of negotiation, which is the basic concept is, what is life going to look like if we don't make this deal today? What's going to happen if we don't get it done? And it's something to always keep in mind. I certainly do use that concept in directing a conversation toward the concept of settlement, right? So like, I ask people things like, what does life look like for you tomorrow if we settle this case today? What does it mean? What does it feel like for you when your head hits the pillow tonight if we settle this thing today? And you should set a calendar reminder for yourself for 6 months from now, okay? So that 6 months from now, when life is returned to normal and you think everything's just as it was, you get a reminder on your calendar to be thankful for the fact that you're not dealing with this case anymore, and that you haven't been for 6 months, because we're settling it today. It's always like, I refer to it as what's behind door number 2. What's behind door number 1 is we're getting this thing done. And what's your alternative is what's behind door number 2. And it's a powerful concept to frame a discussion around making a deal.
And Bianca, can I ask you, have you come across the notion that when negotiating, you should always write down your objectives before you go into the mediation?
Oh, Nigel, I think that you are the king of this. I think that you are the king of planning and preparing. And I think it ultimately makes a party stronger if they have a sense of where they'd like to be. Because entering into a negotiation with sort of this sort of wishy-washy kind of, well, we'll see what happens kind of approach ultimately weakens your position when you actually enter into a negotiation. I think it's important that parties understand where they'd like to be, but also that the heart of negotiation means that sometimes we have to stretch beyond those limits.
And that raises a great point, Greg, because if you're in the middle of a negotiation, because really a mediation is a three-party negotiation. And if you're in the middle of that and both parties have a predetermined view, so they've taken my advice, assuming it's my advice, or they just did it, they wrote down their objectives going in. And then during the course of the discussion or the negotiation, some new factor arises, which means that their risk analysis was not correct. And how do you deal with that at that particular moment? And how do you use that to try to reach an agreement, whether it's on a contract wording, whether it's on a mediation for a personal injury, or whether it's simply a commercial dispute?
First of all, I try to talk about what is in their control and not in their control. And a new fact, a salient issue, something that comes up that's a wild card or a new hurdle that was not previously contemplated, creates the perfect example for us to reevaluate. So it doesn't matter how well prepared they come in or what direction they're headed in or how they really want to be in this direction. I get to say respectfully, you can't go that way anymore. We have to look at it differently. At that point, if I've done the other parts and I've earned their trust and I've shown that I've read the materials they sent me and I can display a comfort level and an intellectual understanding of what they're trying to do and have given them the respect they deserve for where they were previously, people are more receptive to ideas that I may have, because I might have seen this hurdle 1,000 times. It's the first time they're seeing it, or the first time in this case they're seeing it, but I might have seen it 1,000 times. But just because I've seen it and know it and understand it doesn't mean they do and can understand it. So I've got to do all the grounding and anchoring to get them to understand and trust in me. So when I do get to that point, I can say, I know a way out. I've been here before. And that's something that happens in a lot of mediations. It's by the very nature of it, it's designed to have something disseminated at the last minute that is new and novel, that someone has been playing very close to the vest. So this is a thing that Steve, you, Bianca, and I run into all the time. And so that's what I do. And I learned that, over the course of doing them so many times. And then, frankly, my training, the things that we've done before. And one of my mentors, Joe Murphy, kind of taught me some of those things. And that's what I've employed. Seems to be very helpful in times when that happens.
And we're running a little short on time, so I'm just going to ask a couple of questions. And then, as I said, we do have a couple of questions, but from participants. So before I get to them, I just wanted to ask, Bianca, what's your view on using computer-aided design and video during a negotiation?
Especially in this environment, the more the better. Honestly, I think it's almost easier for parties to be able to disseminate that information to everyone involved, because all you have to do is click your share button at the bottom of your screen, and your screen is what everyone else can see. So putting that time and the preparation into those visual aids, I think, makes your case stronger, and it's even easier than it ever has been before in this format.
And perhaps I can just go around. Steve, do you have what's your top tip for negotiating virtually?
It's the same as my top tip for negotiating in person, which is don't ever give up. Just keep at it. Just keep doing it. Just never, ever give up. And I tell people at the beginning of the process, they're going to have to kick me out because I'm never going to be the one that calls it off. Somebody else is going to have to do it. And time after time, you get to an obstacle that seems like it's going to be insurmountable, but if you just keep chipping away at it, if you just keep making just a tiny bit of progress, eventually you get where you're going. And I tell people all the time, I don't care how slowly we're going, as long as we're moving in the right direction, we're going to eventually get there. And I don't have anywhere else I want to be right now or anything else I got to do today. So we're just going to keep hammering away at it until it's done. That's my fundamental approach to everything, virtual or not.
Greg, do you have a top tip?
The top tip is similar to what Bianca and Steve said. I assure folks that in a mediation, I'm not stubborn, I'm not obstinate, I'm not deaf. I hear you, and I hear you when you make a line in the sand that you're never going past, and I'm still going to come to you and see if we can go a little bit farther. We can push a little bit more. At the end of the day, I think people appreciate it. They appreciate that dogged approach. They also appreciate when I follow up after an impasse a week or two later or 6 months down the road and go, hey, remember me? And especially when they didn't initiate that contact, I find that they're really receptive to it. And then neither side feels like they're showing weakness because I've instituted it. I'll get them both together and we get another look at it, a fresh look at it. Especially during this pandemic where we don't know when we will be able to get back into a courtroom, I highlight the fact that, hey, we might have to sleep on this and come back to it a little bit. And we just show that dogged determination. I think what Steve and Bianca said is exactly right.
And not that anybody has asked, but I'm going to let you know what mine is in case you hadn't guessed from the past 55 minutes. For me, it's about preparation. The more you prepare before your negotiation, the more successful you're likely to be at the mediation. So with that, I thought I would start with some questions because we've had more than a couple come in. So the first one I'm actually going to ask Greg. Is the preliminary Zoom session conducted with both clients' counsel or each separately?
I do it usually with one side. I'll have the plaintiff, the civilian, as I call it, in a mediation, and their attorneys helpful. What I've seen sometimes is people want to bring a relative or colleague or someone in the room. I'll get them on the Zoom thing too. And just, you give everyone the respect, you get them caught up to speed, and then they're sort of trusting of you as someone who's making this possible. But I've done both sides on different days. I've done both sides on the same day. But I'll offer to anyone who wants to do it. More and more I've seen that defense attorneys and defense adjusters by now have done a couple. But even today, it was the first time for everyone, and we had a little bit of a remedial session to get on board, and then we were able to move forward.
Thank you. I'm going to take this next question because I have done what has been asked. Have you virtually mediated a case with a party with a language barrier? If so, were there any unique challenges or benefits with virtual mediation and language barrier? So the answer is yes. I've actually done many, actually hundreds of mediations in Latin America. And for those of you who have spoken to me in Spanish, you probably understand my limitations. In other words, I'm very, very limited in my ability to speak and communicate in Spanish. However, what I found when I was doing those mediations was that I was very good at connecting with the parties. So using emotional intelligence, using my gestures, using my expressions. And in those circumstances, and also showing respect. Because I think the one thing that is universal, whatever jurisdiction, whatever culture, whatever language, is if you demonstrate respect to the other side, it will be recognized. It may not ultimately get you what you want, but it will be appreciated. So from a personal perspective, I found that that was at least as effective as my Spanish. And it really helped tremendously in getting the majority, in fact, I think all of those cases resolved. I think in terms of unique challenges with a virtual mediation and a language barrier, I do think if not everybody speaks the same language, I think you just need to be very, very patient. And you need to allow a longer time frame than you would otherwise expect. And don't care if it takes you 10 hours, because you need to make sure that the parties who may not understand everything that's being said get the opportunity to understand, whether it's through a translator, whether it's through their counsel, whether it's counsel themselves. They need to fully understand and appreciate what's going on. Otherwise, you're never going to reach an agreement on whatever it is that you're negotiating. So we have a couple more questions, which I've got to fit in about 2 minutes time. So the first one is, so Steve, I'm going to ask you, are there any benefits, which is similar to an earlier question, are there any benefits in having a joint session in a virtual mediation?
Well, I've been kicking around writing an article about this very subject. Yes is my answer. I am strongly pro joint session unless there's some really good reason not to do it. I think it's almost always for the best for the process to do that. And I say that as the mediator selfishly because it's a great opportunity for me to learn about the case. I've read the stuff that you've sent me, but there's no substitute for hearing from the lawyers and the parties what they want to say when they've got a limited amount of time, because then you hear what they think is really important. And so it's extremely important in my own education. And as a lawyer for many years, I would never sacrifice my one and only opportunity to speak directly to the client on the other side of the case, to just say what I want to say to that person directly without having it get filtered through their lawyer. I think it's a valuable opportunity. I'm a huge fan of the joint session. That being said, I do recognize that there are some cases in which it is better to skip it. If there's an issue of safety, or if everyone involved is pretty well convinced that it's going to be detrimental to the process, I do trust the participants' judgment in regard to that. But if somebody comes to me and asks, are we doing a joint session or not, my vote is always yes.
Thank you. And the final question goes to Bianca. How do you deal with a party who keeps interrupting when another party is talking in a virtual negotiation?
I actually think it's a little bit more awkward when people are talking over each other in a virtual mediation, because you really can't hear them. If you're in the same room, you have the opportunity, I think, just from however our ears work, to be able to hear a little bit better what each person is saying. But because we're working in a digital format, those files, and this is probably a little bit beyond my technical capacity, but it really sounds very garbled when folks are talking over each other. So I found that it just doesn't happen that much. You might have those interactions once or twice, but it's just not desirable for people. So they just naturally kind of back off of it, because they understand that everybody needs a little bit more time and a little bit more space to speak. We need to confirm that someone is finished. So that might take an extra second, maybe a second and a half, but most people are pretty forgiving of that. And they understand that, as we said earlier, this isn't exactly the same. We're going to have a few things that we need to adjust, and they're pretty forgiving of the whole process in that regard.
Bianca, thank you very much. And thank you very much to everybody who joined us today to listen to the webinar. We are available for additional questions. If you want to send them in to Miles, we'll try to address them. And again, thank you for joining us. And Greg, Steve, and Bianca, I very much appreciate your help and input today. Thank you.
Thank you.